Hello viewers, I'm Mayank from Team Corporate Law Journal, a drive for sustainable corporate world. Welcome you to our new video on a very sought after topic, that is voluntary liquidation of companies in India. The keynote speaker for this video is Riya Dutta, Senior Associate at Khaitan Co. She has over 5 years of experience working in corporate and commercial law sphere. She has previously worked with Argus Partners and has also worked for various mergers including Reliance, etc. Do not forget to subscribe our channel and press the bell icon for latest updates on our upcoming videos, and stay tuned with CLJ for more brainstorming videos with eminent personalities. Thank you.
Hi everyone, it gives me great pleasure to witness that Team Corporate Law Journal is working with full spirit to explore corporate literacy. I congratulate the entire team for its great initiative, that is the Corporate Law Journal, a drive for sustainable corporate world. I am confident that this channel will play a crucial role in catering to the needs of students from across various fields such as that of law, chartered accountancy, management, etc. I hope that this platform succeeds in creating value-based corporate world and in helping students understand complex legal topics in a simple and lucid manner. Thank you.
In this video, Ma'am will be discussing with us the legal regime governing the voluntary liquidation process in India. She would then take us through the various stages involved in the voluntary liquidation process. She would also enumerate the roles and responsibilities of liquidator in liquidation process. Furthermore, she would share with us her valuable insights on procedural consideration a company seeking voluntary winding up must keep in mind. Hope you like this video.
Hi everyone. Today I'll be discussing in brief the process of voluntary liquidation of companies in India. The legal regime governing voluntary liquidation of companies in India is encapsulated under Chapter 5 of the Insolvency and Bankruptcy Code 2016, that is the IBC, together with the Insolvency and Bankruptcy Board of India Voluntary Liquidation Process Regulations 2017, that is the Voluntary Liquidation Regulations. The concerned authority for adjudicating the applications for voluntary liquidation is the jurisdictional National Company Law Tribunal, where the registered office of the company is located. The process of voluntary liquidation gets triggered upon a declaration being formally issued by majority of directors of the company to the effect that the company either has no debts or that its liquidation estate will be enough to pay all the outstanding debts of the company. Such declaration is called as the declaration of solvency, and the directors are required to affirm in the declaration of solvency that the liquidation is not being carried out to defraud any person. The declaration is further required to be accompanied by 3 sets of documents. First being an affidavit from the directors, wherein the directors certify and warrant as to the authenticity of the statements made in the declaration of solvency. The second being the company's audited financial statements and records of business operations for the past 2 years or for a period since incorporation, whichever is later. And the third being the report on valuation of the assets of the company prepared by a registered valuer. Now the next step is the shareholders approving the initiation of the voluntary winding up process. So within 4 weeks from the issuance of the declaration of solvency, the shareholders are required to pass a resolution at a shareholders meeting to initiate the voluntary liquidation process. At this stage, the shareholders of the company are also required to appoint a third party liquidator. The voluntary liquidation process formally commences from the date the shareholders pass such resolution. The liquidator is supposed to be an independent third-party insolvency professional who is not related to the company or to the management of the company in any manner whatsoever. Further, the terms and conditions of the appointment of the third-party liquidator, including the remuneration payable to him, is required to be disclosed in the shareholders' resolution. Going forward, the next step is the creditors approving the voluntary liquidation process. So within 7 days from the date of the shareholders passing the resolution initiating the process of voluntary liquidation, the process is also required to be approved by the creditors of the company, representing 66% of the total outstanding debts of the company. The creditors could be in the nature of financial creditors, operational creditors, or even employees or workmen of the company to whom debts are owed by the company. Thereafter, the declaration of solvency together with the three sets of documents I just mentioned, which are the affidavit by the directors, the second being the financial statements and the records of business operations for the last 2 years or for a period since incorporation, whichever is later, and the third being the valuation report, is required to be filed with the Registrar of Companies and the Insolvency and Bankruptcy Board of India within 7 days of obtaining the approval of the creditors. Now, I would like to briefly touch upon the roles and responsibilities of a liquidator. Now, once the liquidator is appointed by the company, please note that the management of the company comes under the control of the liquidator, and the liquidation estate is held by the liquidator on a fiduciary basis for the benefit of the creditors of the company. The responsibilities of the liquidator include making a public statement and requesting for submission of claims from various creditors. Second being verification of those claims. Third being instituting and defending any legal proceedings for or against the company. Fourth being valuing and selling of the assets of the company. Fifth being opening a bank account on behalf of the company for making any payments or for receiving any payments for and on behalf of the company. The IBC as well as the voluntary liquidation regulations allow the liquidator to engage professionals at a reasonable cost to assist him or her with the liquidation process. The liquidator is also required to prepare a preliminary report at the initiation of the liquidation process, and also a final report once the liquidation process is concluded. Additionally, if the liquidation process does not get over within a period of 12 months from the liquidation commencement date, an annual status report is required to be filed by the liquidator with the NCLT. The liquidator is required to ensure that the assets are liquidated in a time-bound manner to preserve maximum value of the assets. The proceeds of liquidation are required to be distributed within a period of 6 months from the date of realization. The cost and expenses that are incurred for the liquidation process are required to be deducted from the liquidation proceeds. These include the fees of the liquidator and or any other professional that is engaged by the liquidator for assisting with the liquidation process. After the company's assets are liquidated and debts are satisfied, an application is required to be filed by the liquidator before the NCLT seeking an order that the company be dissolved. The company shall cease to exist only from the date such an order is passed by the NCLT. A copy of the dissolution order is required to be filed with the ROC within a period of 14 days from the date such an order is passed by the NCLT. Now, moving on to the last segment of this session, I would like to discuss some of the practical considerations that any company which is seeking to voluntary wind up must take into account. The first being corporate non-compliances. The company must rectify any past non-compliance under applicable laws, including Companies Act 2013. This will basically minimize the risk of any challenge to the voluntary liquidation process that may be posed by any regulatory authority and would thereafter delay the liquidation process. The second aspect being the company should ascertain if any consent is required to be obtained from any third party or any regulatory authority. Third party could be in the nature of any counterparty to a contract to which the company is a party to. Regulatory authority could be any regulatory authority which has granted the company any consent or permit or registration to operate the business of the company. The third aspect is the fact that the company should ideally cease its business operations before the shareholders pass the resolution initiating the voluntary liquidation process. As discussed earlier, once the date of passing of the shareholders resolution and the appointment of the third party liquidator officially officially marks the commencement of the voluntary liquidation process, and therefore the company should ideally cease its business operations before such a resolution is passed by the shareholders. Now, moving on, the fourth practical consideration is with respect to the declaration of solvency. Now, before the directors or the majority of the directors issue the declaration of solvency, typically every such director making the declaration makes a full inquiry into the state of affairs and the financial wherewithal of the company. To aid such inquiry, the board typically commissions detailed financial due diligence to determine the company's financial position as well as the market value of the company's assets. Now, the fifth practical consideration is with respect to termination of employees. To avoid any litigation, it is advisable that the company terminates its employees in an amicable manner, that is without any cause, and procures a confirmation that there are no outstanding dues owed to them. The last consideration being historic liabilities. You may please note that even though that the company will cease to exist from the date the NCLT passes the order of dissolution, the liquidation process does not absolve the directors and the management of the company from any past liabilities or breaches of applicable law that the company has incurred. That's about it. Please, I have tried to make it really crisp, and just let me know if you guys have any queries. I'll be very happy to address any queries that you may have. Thank you so much.